Mettiamo per così. Ciao, ci mettiamo per così.
Si vede anche il fatto.
Vediamo che si fermano loro. E ci chiudiamo là perché in realtà la telecamera è là. Non ci vedono da là. It's gonna be 5 minutes. We are okay. Just a moment, we are waiting for other participants that would like to attend the conference. Però non possiamo per entrare con 4 gente perché con questi poi no, li dovete portare altre sedie, mettiamo troppo.
Ecco, io vado via sul
Ce n'è una? No, quella lascia stare. Viene con... Ok.
Mi ricordo questa storia del
Ok, quando siamo pronti me lo dite così iniziamo. Stai già registrando?
Sì.
Allora possiamo iniziare.
Sì.
Ok. Okay, if everybody agrees, we can start. Also, be respectful for the people who are connected by abroad. So thank you, first of all, to Wojciech Postulski, Gösta Petri, and Emanuele Di Cabaron, and I was waiting for Camelli Lal. I don't know if anybody actually connected.
I'm here. Hi, everybody.
You are here, Camelli?
Yes, I can hear you.
Okay, okay, thank you, because we can't see you. Okay, just to introduce this panel, it's a really important new panel in this kind of conference, a Capri meeting conference on digitalization, because we started with this panel only last year. That was the first edition, but this is the 13th edition of the meeting. The idea was to discuss each other about the digitalization, and this year the topic is artificial intelligence, which is very important because we have the Act regulation, and also each country, also Italy, delivered a new regulation. Last week we in Italy had this important law that is the number 152, and bisogna non collegarsi con altre cose, se no fa. And so this is the panel is a little bit changed because we have Giovanni Greco who was missing because he's a little bit sick. So we have Paola Giacalone who accepted to replace him last moment. And also we have Kamel El Halidi al posto on the because Pratek Sibal as another important, it was on travel. So the topic are two. First, we will discuss about the digitalization. And the second part will be on the topic of artificial intelligence applied, especially to jurisdiction. So, without waiting anymore, I greet also Professor Luigi Romano from Naples University, Engineer University, and I give immediately the floor to our coordinator, Giacalone, Paola Giacalone. We have also your brother. Yeah, the connected Professor Giacalone, so it's a family context. Okay, thank you, and I give you the floor. Thank you to everybody.
Okay, thank you very much, Antonella. Thank you again to the speaker to be here today. So yes, this is the second edition, and I would like to thank you all for this opportunity because, as Antonella already said, a dialogue between different kinds of institutions as we are here today, from the European Union Commission connected, and we all thank you, and from the national level, all the possibility to have a better connection, because as you all know, the first goal is to be interoperable between all each other. So thanks a lot. Now that we don't have enough time, I would like to try to assign to everyone only 5 minutes each, because we are many speakers. So please, let's start with 5 to 7. Okay. So you have also the possibility to switch to 7 maximum. I'm so sorry, but we have strict time with our line. So I would like to give the floor to the first speaker today. Please, Antonia Giammaria, Head of Department of the Minister of Justice. We would like to have your first introduction of the scene. Thank you very much.
Thank you very much. Good afternoon, ladies and gentlemen. Today, I would like to introduce you this international sector of cooperation sector of the Ministry of Justice, carries out through the Department of for Justice Affairs. First and most, I wish to thank my colleague Antonella Ciriello and the organizers for the kind invitation to participate in this prestigious annual event, held once again in the beautiful setting of Capri. This conference has become an indispensable occasion for discussion and in-depth reflection on the issue concerning the digitalization of justice, and I'm honored to take part alongside such distinguished speakers. The Department for Justice Affairs of the Ministry of Justice, which I have the honor of leading, perform essential function not only in the administration of justice, but also in relation with the European Union, United Nations, and other important international institutions. In particular, international judicial cooperation activities involve extraditions, European arrest warrants, transfer of sentenced persons, mutual legal assistance requests, and operational meetings with both EU and non-EU countries aimed at addressing critical issues and adopting best practice. Within the department is the Italian section of the European Judicial Network in Civil and Commercial Matters, whose secretariat is based on the European Commission. EJN Civil supports the judicial cooperation in the European level and is composed of contact points coordinated by magistrates attached at the department. Central authorities provided for by cooperation instruments, liaison magistrates, other competent authorities for cooperation. In Italy, the School for the Judiciary and the Ministry of Foreign Affairs and International Cooperation. Finally, professional bodies such as the National Bar Council and the National Notaries Council. EJN Civil also deals with the study and monitoring of Regulation 2844 of 2023 on the digitalization of judicial cooperation and assess the justice in the civil, commercial, and criminal matters at cross-border level. In criminal matters, the Italian section of the European Judicial Network in Criminal Matters is part of the department. Its secretariat is located at Eurojust, and it's composed by contact points, judicial authorities, and other competent authorities for cooperation. The roles of national correspondent and tool correspondent within the network are performed by magistrates of the department. Another important competence of the department is the participation in cooperation with the Ministry of Foreign Affairs and International Cooperation in the drafting of conventions, treaties, and international agreements. At the bilateral level, we negotiate treaties with non-EU countries on extradition, judicial assistance, and the transfer of sentenced persons, coordinated by the head of the department and in collaboration with the Minister's Cabinet Office and the Legislative Office. At the multilateral level, we actively follow European negotiation, providing input to define and defend the Italian position during the legislative phase of so-called trialogue. We also participate in the negotiation of UN conventions, such as the recent United Nations Convention against Cybercrime. We cooperate daily with Eurojust and participate as delegates in numerous working groups and cooperation networks, among which I would like to mention the Working Party on Civil Law Matters, General Question of the the Council of the European Union, the so-called Genocide Network, Network for Investigation and the Prosecution of Genocide, Crimes Against Humanity and War Crimes, the Network of National Experts of Joint Investigation Teams, the Criminal and Legal Affairs Subgroup of the Rome Lion Group of G7 countries, the Working Party on Cooperation in Criminal Matters of the Council of the European Union, the Confederation of European Probation, the Committee of Experts on the Operation of Conventions in the Field of Judicial Cooperation of the Council of Europe, UNODC through the Technical Table for the Implementation of Niamey Declaration against Trafficking in Persons and Smuggling of Migrants, the Euromed Justice Programme with participation in the meeting of Primex, group of judicial cooperation experts composed of practitioners and academics of high level from EU countries and South partner countries. Lastly, I wish to mention another important activity carried out by the department concerning Italia's participation in the European Convention on Human Rights and Fundamental Freedoms. In fact, the Directorate General for Judicial and Legal Affairs supports the government agent in defending the state before the Strasbourg Court, as well as in the execution phase of judgments condemning Italy, overseen by the Committee of Ministers of the Council of Europe. For this purpose, the Office communicates with the Presidents of the Council of Ministers, the Ministry of Cooperation, judicial offices, and the institution involved in the litigation. In carrying out these activities, the department often works in connection with the permanent representation of Italy in the European Union. The function performed by the department at international level are therefore many and highly specialized, requiring a large and highly qualified human resource pool. However, it is now more necessary and appropriate than ever to have digital tools that coordinate and support the work of magistrates and all personnel involved in judicial cooperation. I therefore believe that meetings like today's represent a valuable opportunity to consolidate, also on a human level, these ties that make effective judicial cooperation possible and to understand together the direction we must take to make the best use of the vast potential of the digitalization of justice. Thank you all.
Thank you very much, Antonia Giammaria. As we all know, the digitalization in civil judicial cooperation and in criminal judicial cooperation is a field that was very, very attention by the European Union. And the synergy you're talking about from the Department of Justice or from Italy is fundamental to establish a very good connection between the application of those regulations and directives in this specific sector. And as I know, after we will have 2 other speakers that will go deeply in this specific argument. So thank you very much for your intervention.
Thank you.
So now the word goes to Roberto Conti. He is an Italian judge. He works at the Italian School for the Judiciary member. And here we talk about the training of jurists in the age of AI. As we all know, this is a very hot topic, and it is one of the very goal of the AI Act. It is about what we talk about also in the morning, the AI literacy, that it is, I don't want to anticipate anything from your intervention, but as I said before, a very hot topic of our new regulation. So thank you very much.
Thank you so much, Paola. Thank you so much, Antonella, for this invitation. For me, it's a great opportunity to represent Judiciary School of Magistrates in the public prosecutors. And I'm going to speak with you for a few minutes about my topic is the many phases of SSM on the challenge of AI. My perspective is to share with you the keyword that we could use to improve the knowledge of the Italian magistrates in order to AI topics. And I think that the keyword is cooperation, synergy, as a former colleague. And our school has different phases to realize these topics. We have the central phases, the central dimension of the school that have just organized a lot of seminars recently, and in the next year that will have as topic AI. But it isn't the only phase of the school, because we have also an important phase, an important dimension, the decentralized structures that we have in our school. We have for each district of Court of Appeal a specific trainers that and specific trainers also for European law, so-called Gaius trainers that could realize better the item, the goal of the school in a way where each judge could have the possibility to have a specific contact with the trainer for implement his knowledge about AI. And in the centralized section, there are also focal point, so-called magriff and read, specific figures that have the role to help magistrates that work in the specific territory to improve their knowledge about in a practical way, not only in a theoretical way, to implement the knowledge about AI. In Italy, we haven't a survey about how judges use AI instruments. We know that, for example, in France, we know that there are 44% of judges that just use AI. In UK, we have another survey that shows us that about 28% use AI. I don't know in Italy how many judges use AI, but I'm sure that it's necessary to give us a good training about these problems, not only for magistrates, but also for the society, for the people that go around the justice. And so our school has also another dimension, the international dimension, because our school is not only part of EJTM, network of the European magistrates, where there is a specific subgroup dedicated to digitalization, but also in an international dimension, because we are associated partner in 3 international projects with other institutions, universities, or other schools, where the topic is AI. And it's important that for us, therefore, our magistrates, it's a very, very important opportunity to have a training in a comparative perspective, because we could compare our way to intend AI with other reality of other countries, other foreign countries. And so I want to remember only two projects that was financed this year, the split project. Just a moment, at the slide. Yes, where this project is coordinated by University of Brussels, and there are a lot of countries, and it is focused on general digital skills, and with a lot of topics: digital justice, data protection, cross-border cooperation, online crimes. And in this project, there is a specific topics on training for trainer, because I think that it's a very, very crucial question, not only for the international dimension, but for the national dimension, because if we don't give to read, to trainer in the decentralized dimension, we couldn't realize the goal that we have. So the other projects very, very important for us is Trust AI project. The acronym indicated transparency, rule of law, understanding, and safety in AI for criminal justice. This is this project has a focus, a specific focus on criminal justice, and I have the idea that we could create a sort of similar to blueprint in EJTN, a box where we could create a model that after each part of the project could use in relating to the specific necessity of that there are in a singular reality of the partner. So I finish, and I recap my speech, and in my opinion, it's absolutely necessary to achieve knowledge about the national and supranational dimension of the AI, and it is also necessary to create a common confidence, a common cooperation between different dimensions and different phases that we have in each part of Italian and in other countries. And it's important to achieve this idea of confidence. And I think that, yes. So, finish. Thank you so much.
Thank you very much. So now we realize the relevance, so the fundamental importance of training at the national level for topics who are relevant not only for NASH at the national level, but also in international topics. And you also highlighted the significant contribution of the Italian magistracy in European Union project, as we are part of the Italian magistracy is part of the two fundamental European Union projects, and one is for trainers and the other one includes the part for trainers. And we are very happy to, I'm also part of one of them, so I'm really happy to be here with you also in relation to the first one, you cited the split project. So thank you very much. So now the word goes to the European Union Commission. We have Wojciech Postulski, who is online. He is the team leader of judicial training, DG Justice and Consumers. So the question now is, what is the role of judicial training in turning into reality the digitalization ambitions? So really, we can't wait to listen to your presentation, because I really enjoy the topic you decided for us today. Thank you very much.
Thank you very much, Madam Chair. Thank you for the floor. Thank you for introducing my topic. Thank you to you, Antonella, for inviting me and thinking about the training perspective for this event. Already, Mr. Conti gave a very good introduction to the importance of judicial training. I will zoom out a bit and present European perspective, starting with saying why in the European Commission we believe that judicial training has a role to play when we talk about digitalization of justice. Of course, digitalization using of IT tools, AI, have one goal, to increase capacity of justice systems, so to make them more efficient, to deliver higher quality services at reduced cost. In a bigger picture, to contribute this way to the growth and competitiveness. And why the training is instrumental? Because it cannot happen without, this transformation cannot happen without empowering justice professionals, judges, prosecutors, court staff, and all the others free professions, without building their capacity. That's why, in our eyes, judicial training should create a supportive environment for the digitalization of justice. And this supportive environment would be the essence of the new European judicial training strategy. It will be adopted very soon, in the second half of November, by the College of the Commissioners, and then very widely promoted. We will be reaching out to all of you, promoting this strategy and its objectives. And as said, it will have a strong focus on digitalization. But what does it mean? What do we mean that there is a need to focus training on digitalization? You will see it in the strategy. There's one main objective: to build the digital capacity of justice professionals. And that has three elements. Element number one is to build their IT and AI literacy, so to invest in the skills of professionals. Second element of this objective is to build a knowledge of substantive and procedural as well law that is related to the digital economy and digital society. And third, very important, sometimes forgotten or omitted element, is the need to build the awareness of justice professionals, what it is digitalization, what it is AI, how it relates to their daily work. Allow me to spend a few minutes on each of these topics. AI literacy or skills, IT literacy, AI literacy skills. Every justice professional must be able to use effectively digital tools. They are coming at the national level, they are coming at European level. Let me give some example at the European level. Of course, they aim to enhance the cross-border collaboration procedures. Very recently, the digitalization regulation has been adopted that will digitalize 24 cross-border cooperation instruments. Already now, we have in force some instruments like the evidence or service of documents regulations, who already since May this year oblige professionals to use IT system to put in place these mechanisms of cross-border collaboration. So to do so, professionals must have these basic skills, ability to use these IT infrastructure, IT tools that are created at both levels. But it's much more than that. They have to be able to access digital databases in the cross-border dimension as well. They have to be able to manage their cases digitally, including using the video conferencing. Since the pandemic, we are more or less aware what does it mean, but it means a lot for the justice professionals. That's why we mention here e-judgecraft. Commission was investing a lot in the judgecraft without E at the beginning in the last years. So the craft of judging. So all these abilities to correctly communicate with the parties, manage the courtroom, manage the cases, etc. But now it's time to talk about the e-judgecraft, because professionals must be able to manage e-cases in e-environment online, must be able to communicate to the parties correctly when they see them only on the screen. That's a huge challenge for the professionals, and that must be subject of the training. And the last aspect of it, when talking about the using the tools and infrastructure, we cannot forget that using all these, we have to respect the procedural rights, fundamental rights of parties, of suspects, accused persons, requested persons, victims, children, vulnerable groups. We can list it for long. All that requires training. Knowledge. I will not be naming here the newly adopted EU instruments. You can see some of them on the screen that are now in force to adapt our reality and our legal context to the digital society, digital economy. And of course, such a laws will keep coming at EU level and at the national level. So it's a must to keep training judiciary on these acts, how they relate to their daily work, what does it mean, how they impact the cases they hear, and their work reality. And of course, that refers as well to the jurisprudence of the Court of Justice, obviously. But let me move to the awareness, because that's the topic that, as I said, is sometimes forgotten, omitted. We talk a lot about the potential of the new technologies to simplify our work, to increase our efficiency, and that must continue. Judges, prosecutors, court staff must have the positive attitude, but also they have to be aware about the risks that are coming. Here, I mean mainly the impact of technology on the fundamental rights. And let me here mention a very crucial report that will come very soon from the Fundamental Rights Agency. It will be published early November, in a month more or less, report that will present the findings of the research on the impact of digitalization of the fundamental rights enshrined in the Charter. Please follow that, and once published, please study that carefully. That is a very important aspect that to make professionals aware. They should be trained on the interplay between AI and principle of judicial independence. The big risk that is coming is over-reliance on AI. And you must remember that in the justice sector, it's important to build on the human judgment, not on the machine judgment. And on my last slide, I will refer to how we see the process of implementation of this key objective. What we are to train, it's quite clear. I was trying to present it. Training is not sufficient. Mr. Conti was saying that some studies say that in some member states, 44% of judges use AI, in another 28%, which is optimistic. But on the other hand, our judicial training report of last year shown that all in all, in Europe, in EU, only 3% were trained on how to use AI, and 10 times much more use it. So we see a huge gap. New approach on how to train is needed. We very much believe in the Commission that we will not achieve the success, we will not achieve our objectives without coordinated approach, without joining the efforts of the national and European level. Every professional must be trained, depending on their roles. Different thing must be trained to a judge, different to the court staff, different to the prosecutor, to a lawyer. And the content differs depending on the national context. So we cannot do it at EU level. EU support, EU money can't do it. The projects that we are happy to finance, like Split or Trans AI, that have been mentioned here, there are some of many that we finance within the work of my team. They will not do the job. The job must be done at the national level. Our role EU role will be to support coordination of such a training. Here, how we see the new role of EJTN, European Judicial Training Network, not to deliver training activities, but to coordinate national level activities, providing national institutions like the Italian school with the tools, with the modern blueprints, as you named them, Mr. Conti, to help you deliver at the national level to everyone. But as said, the Commission will continue supporting the judicial training with the Justice Programme, current one under the current MFF, last year, so the current multi-annual financial framework, but under the next MFF as well. But important role should be played by national and regional partnership plans. Please make good use of them. These are the plans that you, member states, must prepare, identifying your priorities, and they will be financed by EU money. So we strongly encourage you to include among the national priorities the digitalization of justice and the related training. Not only to answer your obligations that are coming from Article 11 of Digitalization Regulation or Article 4 of AI Act that clearly say that member states must train justice professionals, but these plans will help you to finance training on all these three objectives that I have mentioned. Commission will be here all the time, helping you financially, helping with the coordination. You will read the details how we want to do it in the strategy, as I said, to be adopted at the end of November. We plan for February a big conference with the Cypriot Presidency, where we'll discuss in detail the objectives of the strategy and discuss with you how are we to implement it jointly. So I'm looking very much forward to our cooperation, and thank you for having this topic today on the agenda. Thank you.
Okay. Thank you very much. It was really interesting, actually recap all our obligations for the European Union according to digitalization regulation and the AI Act. Actually, in Italy, training is seen in a different way. But as Antonella Ceriello showed us last year, we had here Ingrid Berbo, the president of EJTN, who presented this panel, actually, and she helped us to coordinate the different member states, and also thanks to her, there are different members from different magistracies. So this is not the first time we meet, and we compare the different national levels that are part of the European Union. And as a new goal, we have also the possibility, as we already mentioned, we participated with the Minister of Justice to actually European Union project. And the goal, the final goal, then will be to try to start actually from training the trainers, as we mentioned before, and then trying to add the digitalization as a priority also for the digitalization of justice. So I don't know if Antonella wants to add something now. Okay, I leave her the floor.
No, I will only to agree with you that it's really important to train the judges, but we have to decide what is exactly training, because we are facing a sort of revolution due to the artificial intelligence spreading all over the world. So the problem is to decide all the member states, not only the bodies who deal with the training, but also the Ministry of Justice. They have to decide which kind of artificial intelligence, which platform, which kind of artificial intelligence we are going to allow judges to use. So the problem is, are we as a Europe developing a model of artificial intelligence in-house, or performing due to the contract, the agreement we have with those huge industries from all over the world, especially from USA, from China, from India, to how to say, bend that kind of artificial intelligence with a specific data set, our data set, to be useful for, to be sure and useful and trustworthy for judges. In that perspective, only when we have answered that question. So we can speak about training in specifically different. We only can study the phenomenon and trying to assess the phenomenon from judiciary point of view. And now we are facing a situation in which we are developing experimentation about copilot technologies, which is substantially ChatGPT, OpenAI technology, but because with this big, huge company, we have an agreement. But differently, we have to accept the idea we don't have an in-house AI in Europe based on our rights, our principles, and we have to discuss a lot about this. In any way, we all agree it's important to train, to explain the phenomenon, to avoid or to prevent all the dangers we're facing of an uncritical use of this revolutionary technology.
Thank you. Thank you very much, Antonella. So now the floor goes to Marco Gioia, judge, Italian judge, and a friend, let me tell you. He is a member of the DIT, so the International Group at the Ministry of Justice. It's a working group in the field of digitalization of the corporation. I know that Marco Gioia, we talk about the criminal aspects. Then we will have the judge, Federica Acquaviva. She will talk about judicial cooperation in civil matters. And then we will leave the floor to Linda Tomasello, that is online and that's here, and she will be the third intervention. So please try to stick with the time, because I know that this is the first time I tell you, so I will be more patient about this, but please try to stick with the time. Thank you very much.
Thank you, Madam Chair. Thank you, Paola. And I promise I'll try my best to stay in the time. So, as Paola mentioned before, I present the working group on the digitalization of international justice that was established within the Department for the Technological Innovation of the Ministry of Justice. And this group was created in response to the need to address the growing number of initiatives at the European level in the field of justice digitalization. So its purpose is to ensure both disciplinary specialization and effective coordination in order to safeguard a consistency of the position of Italy in the various international fora. So, given the particular complexity of these activities, the European Commission itself clarified that members of the Committee for the Digitalization of Judicial Cooperation may be accompanied by experts with specific knowledge in the subject falling within the scope of the Regulation 2844 and the various legal acts that fall within this regulation. So following this indication, the working group under the direction of Antonella Giammaria, the head of the department, and coordinated by Giuseppe Buffone, the Italian representative of the EU Council with a mandate on e-justice, is composed by civil judges, criminal judges, and senior administrative officials, as Linda Tomasello, who will intervene later online. So each member will contribute according to his or her fields of expertise and competence, monitoring digitalization initiative in the justice sector at the EU and international level. Me, as a member of the group and as a criminal judge, I will firstly try to briefly explain the strategic, let's say, activities of the group, in defining the digitalization policies at the EU level, while participating at the EU at the high-level forum for the future of EU criminal justice. And then I'll try to briefly talk about the our work in the implementing the regulation of the regulation 2844. Among the most interesting proposals discussed at the forum of the high-level forum on criminal justice, there were the creation of a living repository of digitalization initiative of national justice system. So we supported the creation of a mapping exercise where member states provide input about the project and tools in digitalization of justice, so that other member states can learn from these experiences and enhance their own digitalization. In the same direction, there is a proposal to create a EU toolbox. So it will be a toolbox which constitutes a repository of AI-based solution or other tools in the justice sector, which public authorities from various member states will be allowed to use. And so this kind of sharing of tools could create a common digital culture in European justice. So in respect of this, the last argument I'll talk about, obviously in this forum, we talked about AI to facilitate criminal investigation and proceedings. And within the forum, there were broad support for the Commission to develop guidelines and code of conduct, and more generally for a coordinated, as Antonella said before, EU action in this field, and also in founding EU tools, AI tools, sorry. At the same time, concerns were also raised regarding the challenges of AI and the necessity of the protection of fundamental rights. The recommendation we supported was to rely on safe use cases, which maintain human oversight, especially on the decision phase, as Giuseppe Buffone told us this morning. And finally, another proposal of great importance was to create a cross-border video conferencing interoperability hub. So in judicial practice, in judicial cooperation, we always have to deal with interoperability problems between various video conferencing tools from the various member states. And this proposal could really help us a lot in setting up a video conferencing and improve in this way the judicial cooperation in digitalization as well. And I have 5 seconds left, and so just to conclude that we also have a big role in the implementation of Regulation 2003/2844, and our contribution is to try and that the IT system developed by the European Commission is fit for purpose and consistent with the national legal frameworks. So this is our work in participating in the Committee for Digitalization of Judicial Cooperation. I hope I was in time, and thank you.
Thank you very much, Marco. We really appreciate your work and what you're doing for the digitalization of justice in criminal matters. As you mentioned, I think that all the AI new remedies that you talked about, actually the toolbox, the new AI toolbox, and also new chances in video conferencing at the cross-border level could be an example maybe for national solutions. So having the possibility to have a look at what happens at cross-border level could help us maybe also at national level to verify whether that system works or not, and then have the chance to include it maybe in national level solutions. So you as an Italian judge could also help us afterwards in this kind of synergy.
We'll try our best.
Okay, thank you very much. So now the floor goes to Federica Acquaviva for, as I mentioned before, judicial cooperation in civil matters.
Yeah, good afternoon, everyone. It's really a privilege to stay here in front of you talking about this great group that Antonella forms at the beginning of her role in March 2025. We were called by Antonella to help her to coordinate European initiatives with the position of Italy. So we started about 5 months ago, and we now manage so many projects. So I will try to explain you quickly 2 or 3 of the most important projects, because it's a very quick work in a long way. So we participate to the coordination group, and we for the activities with the European Community led by Department of the Technological Innovation at the Ministry of Justice. We are directed by Antonella, and I think that the goal of this group is to take together judges, quindi, so people that work in office court, and IT manager, because all of us we manage law, civil law, criminal law, but I think, for my opinion, that we are not really prepared to work on tools, AI tools especially, but technical tools, it's not our work. So the goal of the group is to take together the resource, so the criminal and civil law and the IT. And we are always helped by Linda Tomasello to solve big question about technical things. The coordination group work on harmonized national strategies with European directive, the one that Marco explained you before, and its core is to facilitate the exchange of best practices among the EU member states, to promote the adoption of shared technological tools such as e-justice platforms. We work on e-justice platform in specific context. I will explain you in 2 minutes, and coordinate pilot projects like as Leila, this is a project that Linda Tomasello will explain to you, involving courts and judicial offices across Europe. As part of my involvement in the European Coordination Group, I had the opportunity to contribute, as I said, in many projects. I will explain you the 2 or 3 most important. I will, honestly, I have to speak about the help of the technical IT manager, because they call us about civil matters, and we together answered the question that European Community gave to us. And they are not so, they call us once a week about this question. I participated in Presence. It was a very interesting, to the high-level forum in Brussels in June, 2 months ago, and we had time to discuss the future of justice in digital age. We focused on data quality, that is a real fuel. We talked about in the morning. Machine training. We are talking about training in this session. I think that the most important thing about training is to focus not only of those who build the system, but first of those who use the system for us. So we worked on dataset control, privacy, and also to synthesis of judicial documents. That is, I think, the most important resource of AI, because as they said in the morning, we save time using these tools. Also, I coordinated technical legal projects in civil matters, such as cross-border insolvency procedures. We have a system to manage so many data, and we improve data interoperability between member states. and we try to reduce procedural delays. We work on transparency in insolvency cases with transitional implication. There are a huge amount of this case. We have a huge amount of these cases. In the end, I want to talk about another initiative on protection obligation. We have protection obligation in European context. And here we have to work on the privacy of people, but we have to improve the transition of data. So with Linda Tomasello, we focus on developing digital protocols and share platforms to support protective measures across EU jurisdiction in cases, for example, of domestic violence. These projects reflect a growing commitment to a justice system that is not only efficient and secure, but also deeply rooted in
Ciao
a
ragazzi,
European...
arrivederci, buon pomeriggio. Ciao ciao. Ciao Lucrezia, noi andiamo, eh? Esatto. Corri, corri Lucrezia. Ciao.
Dobbiamo togliere l'audio. Ok. Chiuso.
Okay. These projects that I explained to you reflect a growing commitment to a justice system that is not only efficient and secure, but also rooted in European values like as cooperation, protection, and legal certainty. I want to thank you, Antonella, for the trust to place it in us, that we are going to European Commission to explain what Italy wants to do in this project, and for taking together judicial and technical ideas. And we hope to translate into tangible results for legal profession across Europe. Thank you.
Thank you. Thank you, Federica, for describing the real cooperation in judicial and civil matters. So now the floor goes to Linda Tomasello, who was already cited by all of us. So thank you very much. We will listen to you that you are online.
Thank you, Chair.
Yes.
Can you hear me?
Yes, and we can see your presentation.
Okay. Let me show on full screen.
Perfect.
It's a great pleasure also for me to be here for the first time, and I thanks, of course, Mrs. Antonella Ciriello, our head of department, for this honor she gave to me. And today I will show you the main achievement of our work group for the technical perspective. I will start with the eCodex architecture, because eCodex is the foundation architecture for mainly all the judicial cooperation information system that are going to be digitalized in the next few years. And eCodex has the basic architecture and has become a regulation adopted by the EU in 2022. And the first use cases that became mandatory to use the decentralized IT system are service of documents and taking of evidence, which went live in Italy in the 30th of June of this year. And the results are already visible because we have more than 6,000 users in the system. We have more than 400 judicial offices that use the system, and more than 300 cases that are managed by the system, completely digitalized. So this number can be seen as a big revolution, because you can, of course, think that that was the summer in between. So 300 cases in just so little months, it's a big outcome. Moreover, on the criminal matters, we are focusing on going into production with the IADES. Thank you, Petri. And the IADES is the initial reference implementation developed by the European Commission, and it formerly involved only the European investigation order and the mutual legal assistance. We are now installing the last version of the reference implementation in the testing environment, and in a few months we are going to spread this other system for all the prosecutor general offices and all the prosecutor offices, and give the final users the appropriate training about it. We are also following the e-evidence system project, and also in this, I think that Petri can say we are online with the European Commission strategy and timeline, because the system is expected to be operational in 2026, and will be the system with which the member states will order the service providers to produce or to preserve electronic evidences in criminal proceedings. Going on, we achieved some other projects about the European Order for Payments, that is a civil matter. It was a co-funded project which ended at the end of February 2025, and it is completely integrated with the Italian national civil trial system, and it was a project with the support of the National Research Council. Moving on, we are following the project of the ECRIS-TCN, which is the development of the European Criminal Records Information System about the third country nationals, and it will enable the exchange of information on convictions of all non-EU citizens or stateless people across the member states. And as you can see from the diagram below, it is integrated also with other central systems that are going to be developed or are already live and are developed by EU-LISA. And as the judge before me, Mrs. Federica Acquaviva, mentioned, we were the coordinator for the Leila project. That was a piloting project for the judicial auctions held in Europe. And the project ended in 2023, and maybe in the next future we will try to open again this project in order to spread it with all other countries that wasn't partners at the first project. And last but not least, I would like to quick mention the other projects in which we are involved right now, that are the counterterrorism register, the joint investigation teams, and the transfer for criminal proceedings. These are only a few that we are going on with the activities. All these projects show a clear direction that the European justice is becoming digital and closer to citizens and practitioners. Our work group, of course, is proud to contribute to this transformation, and I personally look forward to strengthening cooperation with Member States and the European Commission on behalf of our ministry. Thank you for your attention.
Thank you very much, Linda Tomasello. I think all your work that you are doing in your specific sector in the judicial cooperation for Italy, representing our nation at the international level, is huge. And we thank you for your work. And really, as a researcher of those specific topics, I know the relevance of digitalization in judicial cooperation, as in civil matter and in criminal matters, and the push that derives from digitalization for those instruments that were not that used before when they were digitalized, can really be for all of us an example for other remedies that are not that used anymore. Really thank you for your work, and I know that it's a lot because on the other side, as a researcher of the topic, I can see all the potentialities of your work, and I really thank you all for your job. So now the floor goes to Professor Gaetano Armao. He is from the University of Palermo, and he will talk about the digitalization as a path to cohesion in the European Union. Thank you very much.
Thank you very much. Thank you to Holt and to Antonella Ciriello for the extraordinary work to arrange this kind of meeting, and to the Article page. The legal order of the European Union through the Artificial Intelligence Act of 2024 has introduced harmonized rules on artificial intelligence starting from its legal definition, proceeding through the methodology of qualifying high-risk AI system, articulating a comprehensive regulatory framework that constitutes completely legal basis for AI system, consistent with the rights enshrined in the Charter of Fundamental Rights of the European Union. The legislation is situated within the broader context of the Digital Decade Policy Program 2030 and the need to eliminate divergences that hinder the free circulation, innovation, dissemination, and adoption of the AI system and related products and services in the international market, imposing uniform obligation on operators and ensuring uniform protection of the overriding reasons for public interest in the right to European citizens, and more generally connect to the need to guarantee the digital cohesion in the United level. A reference framework that outlined the strategic program for the Digital Decade 2030 established a monitoring and cooperation mechanism to achieve the shared objectives of the targets of European digital transformation. Digital transition offers multiple opportunities: remote work, distance access to the public services, e-health, e-government, up to the possibility of online voting, for which is necessary to address digital divide, cybersecurity threats, and to need a strong digital literacy. Only a strategic program, collaborating among EU member states for the digital decade, can enable the addressing opportunities and challenges of digital transformation. The adoption of an artificial intelligence regulation, AA Act, as you know, has thus aimed at ensure clear standards within uniform legal frameworks for the use of computational systems in order to promote the adoption of an anthropocentric and trustworthy. However, it should be observed that the mere adoption of the common legislative framework without simultaneously activating a vast program of increased citizen awareness, education, and training would risk leaving the EU approach to AI incomplete. The Great Transformation Technology Framework, with the appearance of a long-time traditional form of administrative and judicial decision-making automation and advanced form of digitalization through artificial intelligence, has oriented the legal scholarship to articulate the reserve of humanity, or as preferred to define, the anthropocentric primacy, which should be understood as the minimum sphere of exclusive prerogative of the human being, which the latter is destined to perform the exercise of judicial and administrative functions. The delimitation of such primacy passes through theoretical dogmatic considered regarding the organizational and legal nature of cybernetics and algorithms, and offers a propulsive thrust to the analysis of dynamics in the administrative law, for example, lead from procedure to judgment, guaranteeing in any case and anchoring to fundamental principle, in particular the reserve of humanity in application of the aforementioned objective to guarantee an anthropocentric and trustworthy perspective. In this sense, the Article 3 of the new Italian law established that general purpose of artificial intelligence system and models must be developed and applied in the respect of the human autonomy and decision-making power, harm prevention, knowability, transparency, explainability, and the principle referred to the paragraph 1, ensuring human oversight of interpretation. This represents an initial milestone, of course, which, by enshrining anthropocentric primacy, constitutes an element of enrichment of the regulatory framework applied at the European level, but which it will be necessary to monitor in the implementation it will receive the delegated legislation under the new law. The administration and the judge of the algorithm will be called upon to cultivate also, with respect to computational results, the exercise of discretion and critical evaluation, managing both algorithm bias and structural bias. Hence, the need to pose questions correctly and completely, activating the interaction between administrative and judicial structure and AI, in which the former retain awareness and their own role, not as an act or self-revelation, referential legitimation, but rather as an act of consciousness, the true final differential attribute between person and machine, consciousness of the context of one's own decision and of the impact that is destined to how they live and one fellow human beings, guaranteeing not only anthropocentric primacy of decision, but above all, that all the decision itself is a dimension in which AI offers an opportunity augmented anthropomorphism, in which our cognitive capacity are augmented by the machine. It is very important to link the development of the implementation of AI with the cohesion policy of European Union. There is a direct relationship between AI and cohesion policy. Digitalization, territorial divide, operate as a vector and opposite side, provided the public policy and rebalances in terms of infrastructural and instrumental investments. Strength to the digital services, consolidation of the competencies of human capital in its continuous updating, guarantee active cohesion. Italian law, number 132 of 2025, having stipulated an article that identifies the principle of governance, research, experimentation, development, adoption, and the application of artificial intelligence. In particular, the previous of this law shall be interpreted and applied in conformity with the regulation. It's a very, very particular approach of this law, because we know the Italian use of the gold plating, you know, the use of create Italian law with a huge number of new regulation when we apply the European law. In this law, we find a completely different approach. For example, Article 16, we apply the European law without additional obligation or correct and complete alignment, or the experimentation and use of artificial intelligence system are authorized by the Ministry of Justice after consulting the national authorities. A sort of different approach to the European law, and that is very interesting, and we will see in the implementation of this law what will happen in the Italian law. In conclusion, the European national regulation, as previously stated, tend to offer an initial legal reference framework for what is emerging under European Union legal order, as pointed out an Italian scholar like Santi Romano in 1918. A legal order that is gradually taking shape provides rules and impetus development requiring immediately strong embarkments and secure anchorage to the principle, as pointed Antonella and Antonia. A multi-level legal order in which European legislation integrates with the member states and regulatory agencies. In this perspective, simultaneously ambitious and complex, in which regulators will bear the responsibility of delineating progressively the appropriate rules, while jurisprudence and legal doctrine will offer an unprecedented perspective and new regulatory horizons. Federico Faggin, a very important scholar in the sector of computer, pointed out about the reservation of humanity. I believe we are in the point where science must integrate the inner and qualitative dimension of consciousness experience with quantitative and symbolic analysis. Artificial intelligence, by its nature, processes symbols following programmed and learned rules. It can imitate certain aspects of human intelligence, but authentic meaning requires in experience of a feeling that machines do not possess. Thank you very much to all for your kind attention.
Thank you very much, Professor. Thank you. So now we are changing our topic. We will talk about AI, so artificial intelligence in the European Union. So why not starting with the team leader of the e-justice? So we will listen to Gösta Petri presentation right now, and he will, as you all know, they are preparing DigiJustice, the digital strategy. So we look forward to hear some spoilers, and we would like to verify. Okay, thank you. We can see you. Yes, this is the presentation. Thank you very much. But we cannot hear you.
No, because I didn't say anything, but I think you can hear me now.
Yes.
Good.
Yes,
I will
thank you.
start the slideshow. Okay. Okay, well, we can do it like this as well, I think. So thank you very much for inviting me to join this interesting conference, which is indeed very topical for us and comes at a very interesting moment when we are in the Commission currently working on the preparation of the strategy for digitalization that we intend to adopt in the late November. 19th of November is the current plan. I am, of course, a bit saddened by the fact that I'm not able to be there on the spot in Capri, because I'm sure that is much nicer at this time of year than in Brussels. But this is being there online is, of course, the next best thing. So I was asked to talk a little bit about our take on the use of AI in justice. And as you all know, of course, the main kind of deliverable or the main regulatory framework, of course, in the EU is by now the AI Act that exists as the law of the land in Europe since 1st of August 2024. So it's been in application for a little over a year. And this is, of course, I would say a major achievement because it affirms the EU as a regulatory leader for technological development, because it's the first comprehensive legislative framework for AI in the world. This basically the idea of this AI Act is to kind of make sure that AI systems before they are actually being applied in practice, that they meet certain requirements, and notably requirements regarding compliance with fundamental rights. And it's a kind of phased application over 3 years of this regulatory framework. So the AI Act categorizes AI systems by risk. It's a risk-based approach, if you like. So there's four levels of risk. Unacceptable risk, basically those AI systems that are prohibited because they are too risky, and social scoring is one of those type of AI systems. High risk is the lower level, and that is what is the interesting category in the field of justice. I will come back to that. And there, high-risk systems are permitted, but subject to compliance with certain requirements, and they have to be assessed for their conformity prior to being released, as I mentioned earlier. Then we have a lower level risk that sometimes is called the transparency risk. This is where you are permitting AI systems, but you have requirements to provide information, in particular then information that you are actually interacting with an AI system. So in a chatbot, for instance, there is a requirement that you have to be made aware that you're talking to a chatbot rather than to a human. And we have the fourth category, of course, which is minimal or no risk, where there are no restrictions that apply. Looks like that. Then we have also an additional requirement in Annex 3 to the AI Act, which is then specifically targeted to justice, as I mentioned. So there's a kind of list in this Annex 3 with a certain number of sectors or which are considered to be high-risk systems. So that's number 8 there here that interests us, administration of justice and democratic processes.
I'm sorry to interrupt. There is a problem with the presentation because it's stuck. The presentation is blocked, actually.
It's blocked?
Yes.
Yeah. Stuck on the first slide.
We only see your first slide.
Okay, I don't know, but it's true. I cannot start the slideshow. Okay, well, let's try again. Yes. Okay, do you see it? What do you see now?
The same.
Okay, maybe then I should stop sharing and try to share it again.
Thank you. Yes.
Maybe that, I hope that will help. Sorry for this. Technical hiccup. Maybe I should have used an AI, no? Okay, so do you now see the slides?
Yes.
And if I move, does it do?
Okay, yes, now we can see. Yes.
Second one, okay. Okay, so here's about Annex 3. Can you see that one?
Do
No.
you want to put? Oh, okay.
Is it okay?
Yes. Yes.
All right. So I was saying then that we had this particular listing of in Annex 3 of justice, use of AI systems in justice, and it's about administration of justice and democratic processes. And this refers then to AI systems intended to be used by a judicial authority or on their behalf to assist a judicial authority in researching and interpreting facts and the law, and in applying the law to a concrete set of facts, or to be used in a similar way in alternative dispute resolution. So that's then basically, you could say, in simpler terms, that it's about judicial decision making. There is, in addition to this, a kind of sort of derogation from this in Article 6, paragraph 3 of the AI Act, which is sometimes called the kind of filter. So just to say that regardless of the Annex 3.8, an AI system shall be considered not to be considered to be high risk when the system is, for instance, when certain conditions are fulfilled. The AI system is intended to perform a narrow procedural task, or to improve the result of a previously completed human activity, etc., and a number of other, while also performing preparatory tasks to an assessment, or detect decision-making patterns. And that is, of course, something that may apply to a number of systems potentially to be used in the judiciary. Okay, so now I'm coming to what we are doing right now in the Commission then, and in particular in my Directorate General, DG Justice and Consumers. So we are supporting our colleagues in the DG Connect, because the Commission is about to provide guidelines on practical application of this provision on high-risk AI systems. And that covers also then this point 8 that I mentioned, administration of justice. So we have the colleagues in DG Connect, or more precisely, they call themselves the AI Office, and they are then talking to member states, competent authorities about what issues are raised with these provisions on high risk in the AI Act, in order to find out what kind of guidelines to provide. And there was a workshop also, I think this spring, organized by the AI Board subgroup on high-risk systems to discuss these matters. There was a public consultation launched in June this year, and the idea is that the finalized guidelines will be published in February next year. And then some questions that have been discussed in this context, particularly regarding this provision on high risk for justice. It's like questions, what does it mean when an AI system should assist the judicial authority? Which kind of examples could one think of? And one quite interesting question is about this derogation that I mentioned, because they are used for or intended for purely ancillary administrative activities. And here is one example, anonymization or pseudonymization tools. Okay, so that was about the guidelines and the preparatory work for the guidelines. That we heard also today about another aspect in the forthcoming digital strategy, the IT toolbox for justice that we are going to work on in the Commission. That's one of the work strands that the strategy will contain. And the background for this is that we think that the member states are progressing a bit unevenly in the digitalization of justice. most member states have the same needs and may also therefore need similar types of solutions to achieve digitalization. But of course, it costs a lot of money to develop tools and also to develop AI tools. And that's why we are intending to develop this kind of IT toolbox to support member states in really making a leap forward in digitalization of justice systems. And there we will bring in tools, of course, developed by member states, in particular, mainly the tools that are there and the member states wish to share. And it will obviously be a large part of this will be actual AI tools, because that is what is really useful, we think, for use in justice. Provided, of course, that the tools are compliant with the AI Act. So final slide here about the AI in justice, what we have been doing in parallel with the AI Act. We have discussed for the last years within the Commission and the Council on digitalization of justice and on AI, and collected information and held discussions. And in our field then of justice, the Council approved Council conclusions in December last year on the use of AI in the justice field, and that includes also the wish of the Council to develop this kind of AI toolbox that I mentioned. And with that, I conclude my presentation. Thank you very much, and apologies again for the little technical hiccups.
Thank you very much, Dr. Petri, for your presentation. So now the floor goes to Kamel El Halili, legal AI expert from UNESCO.
Thank you very much.
Okay.
So I'm sharing also my slides. I hope you can see the screen and the slides now.
Yes.
Yes.
Okay, perfect. So I have 7 minutes to present you with an overview of the AI and the Rule of Law program, and I will focus on 3 main topics here. I will talk about the training and capacity building that UNESCO provides, because this has been the topic of the previous conversation, and I would like to inform you about what we do. Then I will talk about a little bit about the use of AI that we have identified, as well as the limits, and I will comment on what was said by our colleague Petri from the EU Commission on the risk and the high risk classification under the AI Act, and then I will briefly discuss the guidelines that have been published by UNESCO on the use of AI by courts and tribunals. So I just want to start with a quick introduction to mention that UNESCO has been engaged since 2013 with judicial operators around the world to help them gain knowledge and build their capacity as regards to diverse topics related to freedom of expression, safety of journalists, access to information, and as we moved on, questions related to social media platforms, content moderation were raised. And then the topic of AI became more and more concerning for member states. So we received requests to develop programs and assistance on this question. So in 2021, as perhaps some of you know, UNESCO member states adopted the recommendations on the ethics of AI, which was broadly adopted. And then in 2022, UNESCO launched its AI and the Rule of Law program, which is funded by the EU. Basically, the mission of UNESCO is to provide assistance and build capacity, offer training to judicial operators, broadly speaking, meaning judges, prosecutors, court staff, members of civil servants working for ministries of justice, but also lawyers on AI, ethics, and human rights. The capacity building takes many forms. So we have reached and engaged more than 36,000 judicial operators from 160 countries. We have signed more than 11 memorandum of understanding with regional courts, international courts, and we have developed a series of MOOC. We base our training programs on what we call the Global Toolkit on AI and the Rule of Law for the Judiciary, which is freely available online. We conduct different series of training. Some of them happen online, just like today. We also have in-person training at a national or regional level. So we conducted a series of training for the Caribbean Court of Justice recently. In Rwanda, I will head to Namibia by the end of the month to train parliamentarians and judicial operators on AI and the rule of law. We conduct these trainings in multiple countries. We partner with local authorities, magistrate schools, to make sure that the training we provide is contextualized. I just put here a quick map of what we do and the countries in which we have been intervening. What we've learned from all of these training sessions that we organize is a couple of things. First of all, there's a high interest and demand for AI and for training about AI in the justice system. Second of all, the needs are universal. What people are needing is AI tools that help them reduce the workload, reduce the stress for repetitive administrative tasks. We also see a huge disparity between countries. There are the countries who are well advanced and developing their own AI systems at the court level or at the government level, AI systems for the judiciary. And on the other end of the spectrum, you have countries, including some EU countries, who have tough times digitizing court decisions. So we are working on that. The next thing we are doing is providing continuous online training through MOOCs, so massive open online courses. The first one was published in 2021. It's still available online on AI and the rule of law, and we are now working with Oxford University to prepare a new MOOC on AI in the judiciary, and this one has two kind of innovations. The first one is that it's targeted so that judges who have a limited availability can only follow the modules that are of best interest to them and that can serve their daily operations. The second innovation is that we included modules on emerging issues that are raising, such as the intersection between Gen AI and evidence, procedure, fair trial, intellectual property and data protection, but also questions around constitutional law, women's rights, and content moderation. The final innovation in this module is that we will include what we call an AI safety checklist for judges. And the safety checklist should help judges to ask themselves the right questions when they are confronted with, let's say, a piece of evidence which is produced by or with the assistance of AI. We have a lot of publications that are available online. One of those is the guidelines that I will briefly talk about. I just want to point out here two efforts that were led, one by UNESCO, one by the Council of Europe, to map available AI systems for the judiciary. So the first one is here from CEPEJ. I included the QR code for people who are interested in this one. I heard a colleague earlier today saying that he will be working on creating such a repository. So this is a good source of information. And UNESCO recently launched its Radar tool. The Radar tool is a repository of open AI tools available online. So it contains a list of openly accessible and also private tools that are used in the judiciary around the world. And the idea from UNESCO's perspective is not to prescribe the use of AI, but merely to inspire countries who are looking for innovative ways to help the judiciary perform its task, to learn what other countries are doing. So let me now quickly talk about the guidelines for the use of AI. We know that judges and courts around the world are using AI systems to save time, be more efficient, reduce stress, and so forth. And we conducted a survey in 2024 around more than 560 judicial operators to learn how they were using AI, why they were using it, and what were the risks. So we learned two important things. The first one is that 44% of respondents were already using AI system. The most used tool was ChatGPT, of course. The main tasks that were used the main reasons they were using AI systems to perform research, to draft documents, including drafting decisions, and to brainstorm, test, and challenge their own ideas. The risks are quite classic and well perceived by judicial operators. It comes through output quality, the opacity of the AI system itself, the question related to confidentiality and data protection, and so forth. And the last thing that we realized through this survey is that only 9% of judicial operators get some sort of training or recommendations from their institutions. This is why we created the UNESCO guidelines, which takes into account the different threats that we are facing right now in the judicial sector. One of those is the opacity of AI systems, which operate as black boxes. There's also the quite huge shadow AI use among judicial operators, which are using AI systems without reporting it because they are either facing threats or sometimes just a shame of using AI systems. There's also the question of data protection, privacy issues, and sovereignty issues. And so we provided these guidelines, but there are also national guidelines that exist out there, and I listed here a couple of countries which published their own guidelines recently. So our guidelines provide two things. They provide a list of principles for the development of AI systems. These are freely available online, and I can refer you to the document. I'm happy to share the link after this presentation. And we do two things. We provide recommendations for courts themselves on how to integrate AI in a way that preserves the efficiency, but also the judicial independence of judges. And we help them understand the type of mechanisms or procedures that they should be able to develop to maintain full control and oversight over the AI systems that are being implemented. And then we provide recommendations and advice to judges themselves. When they are using AI systems, they should be able to use tools that are tested and approved by their court or jurisdiction. They should be able to receive training on a regular basis, avoid over-reliance on AI tools and so forth. And most importantly, a key message from UNESCO is that AI cannot and must not judge, because it's merely a probabilistic tool, and it should never be in a position to replace human judges in decisions, because behind the use of AI systems is the question of the confidence and trust between citizens and the justice system. And this is a strong, this can be a very important issue that we need to anticipate and try to mitigate. We are supporting member states to adapt and adopt local guidelines. So what we do is we cooperate with the Ministry of Justice or Supreme Court to run the process. We set up a task force, which is a small group of judges, court staff, and representatives, to think about how they want to advance and what are the principles that they want to include in these guidelines. And then we conduct a series of in-person and online consultations to make sure that we explain the guidelines, we help people understand the key principles and considerations. We determine the legal instrument useful for transposing the guidelines at a local level. And then we plan hearings and consultations with judges so that they are included in the process. And then we guide the drafting process. This entire process can last between 6 months and a year, and we have been doing this work with Colombia. Colombia has already adopted the UNESCO guidelines at the national level in late 2024. We are now working with Morocco, which this work just started this month, and it will be completed by June 2026. And we are working with Rwanda and Nepal. So given the time, the limited time that I have, I just wanted to flag this. We highlighted 3 types of use cases for AI systems in the judiciary. It starts with the basic tasks, translation, transcription, and so forth. Then processing of documents with some sort of, some degree of legal analysis to find facts, find jurisprudence, cross-analyze cases. And then the highest level of AI uses comes with decision support. And here judges are using AI to draft decisions or to decide on what are the sanctions that should be applied in the case. And here's the thing. It is typical for people to consider that the level of risk and the level of verification should go gradual. So with essential or administrative function, people tend to consider that the duty to verify is lower because the risk to human rights, to the justice system, and efficiency is low. And when we reach to decision support, people naturally understand that there's a high risk that the AI system can commit errors, can hallucinate, and so forth, and then the duty to verify is much stronger. Actually, what we think is that the risk is much more diffuse than that. And even an AI system that just provides translation can commit a mistake in a document, which will have an influence, which can have an influence on the perception of the case, and then on the outcome of the decision. So in from our perspective, and this is very important, even under the AI Act, which distinguishes AI users and AI systems based on the risks that they pose. Even some minimal risks, some AI systems that should just go through transparency obligations should still be classified as high-risk system. In other words, and put more simply, all AI systems used in the judiciary should be classified as high-risk systems, because in case of errors, they can have significant consequences on people and on the confidence that people have in the justice system. And with that, I will conclude and thank you for your attention. I'm happy to respond to any question. Thank you very much.
Thank you very much for your presentation. I think that your link will be very useful for all of us. So if you could share with us your link, I think it could be a good idea for all of us to learn and to be aware of your actually very groundbreaking projects that you are developing. So really, thank you very much for your presentation. So now the floor goes to Judge Emmanuelle Ludic-Baron. She is from the French magistracy, and she's also a very good friend of mine. So hello, Emmanuelle, bonjour. I'm really sorry that you are not here with us this year. Last year you were live, and now you're online. So the floor goes to you. I know that you will be talking about AI. You have a new role in the French magistracy. So congratulations, félicitations. And you will talk about European training on AI. So we all know that France is a leader right now. All eyes are on you because you are developing also a new way of AI in your country. But in your topic, I know you will talk about the European training at the moment. So, merci beaucoup.
Thank you, Paola. I will try to respect the time, so I will go straight to the point with three main topics. First of all, the national example of France regarding the strategic mission on AI and justice and judicial training, which was developed in France this year. Then I will speak about European projects within the justice program led by the Commission, and then I will speak about EGTN and the digital subgroup. So regarding the strategic mission on AI and justice and judicial training, on February 2025, the French Minister of Justice launched a strategic mission to integrate AI into the professional practices of the judicial system. This mission, entrusted to Afid Boulakras, Deputy Director of National School for the Judiciary, aims to accelerate the implementation of AI in the judicial system. This mission was an opportunity to look at the existing training in the fields of digital technology and AI in schools training the judicial professions, not only judges and prosecutors, but also other agents of the judicial field, and made it possible to develop a strategy for the creation of a new training institution called the Digital Campus. The objectives of the campus are very interesting. The creation of the Digital Campus, a system combining a physical place and a digital training space, aims to meet the challenges of the digital transition in order to accelerate the development of skills and responsible uses of AI in the professions of justice, in the civil services, the prison administration, and the judicial protection of juvenile young people. Using AI to modernize school training and strengthen their collaboration is the main objective of this campus. The principal idea is to integrate AI into teaching tools, which will make it possible to pool educational resources and innovate pedagogically through immersive digital tools. The other objective is to train all the audiences in the 4 partner schools and develop a shared digital culture guaranteeing the acquisition of essential digital skills for learners and reducing inequalities in access to training. The hybrid dimension of the digital campus will bring greater accessibility, flexibility of courses, educational continuity, a collaborative ecosystem, a cost reduction, and logistical optimization through the pooling of digital educational resources. The first AI training courses could take place as early as 2026 after the design and development phase of the modules. This physical campus, articulated with an online portal, will thus constitute a real center of excellence for the acculturation and development of digital skills for all justice professionals. My second topic is much more about a European project, and I want to speak about one European project which is called JustFair and is very important for us because the idea is to integrate AI in judicial education. This project was launched in 2025 in June in Barcelona and is a project led by ENM with co-beneficiary Spain and also the participation of the Romanian school, Italian school and Belgium school for judges and prosecutors. This project aims to train judges, prosecutors, clerks, and also lawyers in the use of artificial intelligence while placing people at the heart of judicial decision-making. We planned 3 seminars, one seminar on the use of AI tools in the justice sector. The first seminar was in June in Barcelona, and 2 other seminars, one in Paris in February 2026, the use of AI tools in the justice sector too, but regarding best practices and case studies. And the third one will be in July, the use of AI-based tool by justice professional, more practical again. These seminars aim to bring together judges, prosecutors, lawyers, and clerks from different European countries to exchange best practices and challenges posed by AI in the justice sector. To achieve the specific objectives of the project developed above, the following methodology will be followed. ENM pedagogical team will help design a training kit for future trainers as ready-to-use material as well as for justice professionals as self-training material. Depending on the training needs identified during the seminars, the training kit will consist of a micro-learning module available online for short self-study, a longer e-learning module for more consistent self-study sessions, and a ready-to-use set of training sheets to support trainers in the development of in-person training sessions on the topic of AI-based tools used in the justice sector. Trainers from other participating countries, as I say, Romania, Italy, Spain, Belgium, will also be invited to participate in the seminars so that they can share their views with ENM teaching team in the design of the training kit. It's the more important thing of this project is to share the training kits all around European partners to develop this cooperation in European training regarding AI. And my last topic, to respect the timing, is to speak about the digital group of IGTN and the work of this group. The digital group of IGTN created in order to respond to the necessary need to adapt the network's training to the challenges of both digital and artificial intelligence is leading a lot of seminar from 2025. And I want to insist on the future of this sub-working group working especially on AI. In joint collaboration with the working group on judicial training methods within IGTN, the sub-working group working on AI will carry out an e-learning course which should be held in September and in fact is running now in September, October and November. In addition, the AI sub-working group plans to develop a follow-up to the seminars developed in 2025 on the impact and challenges of artificial intelligence in justice. This group is also organizing a two-day summit on digitalization and artificial intelligence for the autumn 2026. Case speakers from the EU institution will be invited to reflect on the use of digitalization and AI. The focus of the conference will be on the daily work of judges and prosecutors in judicial proceedings through criminal, civil, and administrative law, as well as criminal investigation. The group is also working on innovative ways in which AI is and could be used in the justice system, such as improving access to justice more quickly, as well as the inherent risk of use of AI. To conclude, I can say that AI training for the judicial profession is essential to ensure impartial, ethical, and transparent decisions. ENM's initiative and the Digital Campus project are important steps in this direction. The Just Fair project brings a European dimension to the exchanges on best practices and challenges posed by AI in the justice sector, as well as the impetus given by ENM to IGTNs in the framework of the digital group. And I can say that the role of IGTN in the coordination between our school is the most important for the moment regarding this topic. Thank you very much for your attention. I hope that I respected the 5 minutes, and I'm sorry not to be here this year, but it was too complicated to come in Capri again. So have a nice moment in Capri.
Thank you, Emmanuel. Thank you very much. Thank you also for reminding us the fundamental role of AI in the justice sector for your president, Afid Boulakrev, and for the real hard work of the European Judicial Training Network. So EJTN is doing for training the trainers in each member state. And since I am also part of the digitalization group of EJTN as one of the experts in this field, I really believe in our job. And I hope that it can really try to connect different member states, a comparison between different member states, because digitalization should be really one of the very first topic in training. So really the focal point of training in each member state. And thank you also for delivering your projects that are very, very useful for all of us. So if you could also link your project to in this team's conversation, it would be very useful for us too. Merci beaucoup. So now we are leaving the floor to Ms. Lorenza Calcagno, magistrate. Yes, she is online. We can see you. She is also a member of the CFA, so collaborator, and she will talk about the role of CFA in artificial intelligence. Thank you.
Thank you for the floor, Chair Madam, and I want to thank Antonella, with which I worked for a lot of years, and it's pity that this year was impossible for me to be in Capri. I hope the next year maybe I will succeed to come. I want just to show you, to talk to you in this short time about this project on which I'm working. But I just presented a draft of a program because we are working on it in the next months. Just to remember to all of us that since 2016, the European Commission for the Efficiency of Justice, the CEPEJ, has developed important reference text concerning the implementation of digital justice in the judicial systems of a member state of the Council of Europe. And in 2020 established the Cyber Just Working Group. And in its action plan 2022-2025, it has made in its priority for the next few years to accompany states and courts in a successful transition towards the digitalization of justice in line with European standards and especially in line of the Article 6 of the European Convention of Human Rights. So in these years, the CEPEJ has adopted several guidelines on e-filing, on the digitalization of court, on video conferencing, and on e-auction. CEPEJ has also established a resource center on cyber justice and AI, and this center serves as a publicly accessible focal point for reliable information on AI systems and our key cyber justice tool applied in the digital transformation of a judiciary. At the end, I will surely send you the link, so it's interesting. Maybe it would be interesting for you to come and visit. And I think that there you can find also the information about what speaking our colleague of UNESCO. So the CEPEJ Group Cyber Justice is working now on a model curriculum for judges, which should illustrate the essential knowledge and skills that should be obtained and how this could be achieved in the most and effective way. And this is the project on which they asked me to collaborate with them. And I just explained to you the line of the draft on which the group is working in these months and the next one. So the first question, it could be a technology curriculum for judges. Is it necessary? I think that at the end of just this afternoon is very clear that it is necessary. I just want to stress that when we are speaking on literacy, in some way we are speaking about something before training. I mean, before we need to work on a good literacy and continue to be improved with good training. And it would be very interesting to hear for the project and also for my colleague Roberto Conti about how the Italian School for the Judiciary is doing. What is the idea on this technology curriculum for judges? It's a sort of roadmap from basic knowledge to AI. The idea is not to think about only AI, but to arrive putting the judge in the system of jurisdiction in the time of digitization. And in this case, as you can easily understand, we are discussing about a lot of different countries. So it could be necessary to find the focus point on which work. So the first part is about the aspects of a general training course, and surely is necessary to discuss about the framework of regulatory disciplines of the digitization of justice in the different states of the Council of Europe, and the discipline of AI and the central need of literacy. We just discussed about this point in the speech that were before mine, and I heard that also this morning you spoke about the importance, the real necessary of good literacy. And is good to remember that in the AI Act, there is the Article 4 that I can imagine you discussed before, and it's interesting to remember to assess also by point 56 what means AI literacy. That means skills and knowledge and understanding of all the points. But there is also another article on the digital literacy and skills in the Council of Europe Framework Convention on Artificial Intelligence, Human Rights, Democracy and Rule of Law, that is of May 2024. So the training must focus the role of justice within democratic systems, the fundamental role they play in the rule of law. I have to remember this is is for only the member state of European Union, but it's good to remember the ECJC 64/2016 decision that establishes the close connection between independence of judges and rule of law. And in this perspective, technological training must be framed in terms of a technology at the service of rights. Therefore, with in-depth training on the risk, today we just discussed about this point of the risks that the new system brings by exploiting modernity and the advantages they have. So we can just think of a different access to justice that the digital system guarantee and how can change the way to approach to justice and to the fundamental principle to be able to arrive to this. So the principle for training is that technology is at the service or more efficient, but also effective justice in full respect of citizens' rights. Because this is a point that on which we discuss and we think it's correct that a technological transformation of justice in compliance with the rule of law and fundamental rights is possible only if judges take a leading role in the process, means that they are really aware of the meaning of the word, that the new tools that they are working on. So training on artificial intelligence should be included in the context of an already changed system. Just some words, very short on key areas. We think that one is surely the basic elements of the technology, considering the data with a knowledge of the essential characteristic, potential and limits of the big data technologies. The analysis, for example, also of cloud computing, for example, the cloud technologies with the same logical scheme as the data, and then deal with the algorithms, the linking elements between data and the functioning of AI. But is also involved the principle and ethics value involved. I want to remember and stress that CEPEGI worked a lot also in the last years about the principle and ethics values that has to be remembered all the time on which we are working on this with this tool. And it's important to propose an organic vision of the problematic aspects of the use of AI tools. And this must be done at individual level because we have principles like human dignity, freedom, and civil rights, and non-discrimination. And on this point, I want to focus the necessity to understanding bias. And on these topics, we can have a very interesting work made by the European Union Agency in 2022 on bias in algorithms, and also at social level. And here the principle are inclusiveness, inequality reduction, and social cohesion, but also a view at the global level, and this is important sustainability. So it's important also as a key areas use AI consistently, as I told before, core values and ethical rules, and AI tools must be subject to stringent information and security standard, explicability, and black box. So at the end of this, just to a point in which arrive to have a necessary literacy, is necessary to think about develop a continuous training program in view of the characteristic of artificial intelligence, with special attention to methodology that, especially the methodology that can enable an exchange of experiences. This is just a draft. It will be discussed by the group of cyber justice, so maybe after we can send you when the documents will be done. Thank you for your attention.
Thank you, Lorenza Calcagno. Yes, please, if you could share your presentation, that will be good for us, and all your work. Nobody, I think, in this field can forget the relevance of CEPEI. Your guidelines were the very first ones on the ethical aspect in 2018, so very long time ago, and were the only source that we had in that specific field of AI. So really nobody can forget the role and all your job in CEPEI for spreading the word on the ethical aspects of AI in justice. So thank you very much, and we are very thankful also for the work you shared with us today. So thank you, Lorenza. So now the floor goes to another magistrate, so from the Romanian training school, Amelia Onisor. She will talk about liability for software and AI systems under the new European Product Liability Directive. This is a very important directive, and it's a different topic from the AI regulation, and it's related to AI, because nowadays this directive is the only one who talk about liability aspects in this field, because as we all know, the directive that was proposed in this field for AI as a moment of stop from European Union level. So it is really relevant for us right now to talk and to know more about this directive. So thank you very much.
Thank you so much, Paola. I think I have a problem
with the sharing. I will come right now.
It might work also like that. The idea is that I cannot present full screen, but in the meantime, I can start like that.
Technician.
Thank you so much. So after hearing so many inspiring, just 1 minute.
Just 1 second.
It's so didn't search.
No.
Perfect. Thank you so much. So after hearing so many inspiring ideas about AI in justice, I just want to shift a little bit our position and to talk, to explore the other side of the mirror, how justice works for AI, or rather for those who sometimes might suffer because of the use of AI or software, and when these types of mechanisms of systems have defects. I also prepared a small video regarding practical things actually that I had at the Court of Appeal at some point, but I think I'm not going to show it to you, but I will send the presentation later on for further reference, because it's quite complicated, and I'm afraid 7 minutes won't be enough. Okay, but anyway, it's what I want to talk, and thanks for doing my work easier, Paola. It's about this new directive, because now we are at a turning point, in the sense that we had a previous directive from 85, which 85/374, which defined the products as being a tangible, mechanical or analog products. So at that time, the notion of defectiveness refer to, I don't know, a car that broke on the railway or a machine that malfunctions, things like that, not to softwares, not to AI systems. So it was very difficult for us, for judges, to apply this kind of directive to our days, I mean, to the situations that are much different than they were in 85, let's say. So the technology moved quite a lot, and now we're referring to also to like pervasive software, like for example, what we use, the smartphones have, they all use softwares and AI systems, LLMs, not necessarily as supplementary, I don't know, system, but also integrated in them. So this is why it was needed to just fulfill to fill the gaps concerning the digital products and this kind of objective liability, because this directive I did not mention yet refer to the objective liability, so the liability no matter if fault exists from the part of the producer or not. And when it's referred to defective products. So when an AI system or a software system is defective in a way, in the sense that it triggers some damages, then it was very difficult to decide that this the old directive was applicable. Nowadays, with this new directive from 2024, this in the notion of products, software and AI systems are also included. The member states must implement this directive by December, sorry, 2026. So there is still some time until we adapt to all the differences. But it's time for us also to understand how it works. Over time, so the new rules will apply to the products placed on the market after the implementation date that I have mentioned previously. And the victims, in the meantime, can rely on other type of legal grounds, like contract or negligence for digital defects. That was the case also based on the old directive, in the sense that the Court of Justice also mentioned that this kind of responsibility can be, liability can be accumulated also with other types of liabilities, like liabilities derived from the contract or enforcement. So we have this Article 9 and 10, also from Article 4 from the directive, the general definition of that remains focused on expected safety. A product is considered defective if it does not provide the level of safety that a consumer might reasonably expect. Like, for example, we are not referring to a glitch when you're not happy with the light from your smartphone and you know that it's because of an update or something. This is only a glitch. It's not something that affects your security. So you cannot trigger the liability, the responsibility of the producer for a thing like that. But when the problem is in the level of safety of a consumer, then you can ask for protection from the court. The fact that the defect is made by the software and not by the hardware, and that you have bought the hardware from a producer, it doesn't, I mean, this fact doesn't extend from liability. The producer, it doesn't matter if it was a hardware or a software malfunction. The manufacturer cannot avoid the liability by claiming, for example, that the defect stems from software rather from the physical component, as it was the case previously. What is also interesting is that there is an extended liability period in the sense that from the previous regime, the producer, the manufacturer was liable only for what happened before the product left the shop. Like everything that happened after the sale was not important from the point of view of liability. Now, from the recitals 19 and 50 from the directive, we can conclude that the producer will not be exempted from liability if the defect that caused the damage occurred after the point of sale as a result, for example, of an update or some other thing that happens, like the application of a machine learning algorithm, for example, that learns in time to do things, and at some point it just leaves the correct path or the safety one. So that's a very important thing to know. Then the obligation of producer regarding updates and traceability is also a thing that it is important, and it's related to the new provision, in the sense that if you fail to fulfill the duty of vigilance, for example, not fixing a known vulnerability to an update, let's say, it might constitute a separate fault for the producer, distinct from the product defect. There was a case at some point in France, the Mediator case related to a medication for diabetes, where the manufacturer was aware about the risk of that medication, but continued to sell the medication no matter this thing. And that was a thing that triggered some other kind of, tort or some other kind of liability, not only the one that referred to the defect of the product. That's the case also with the new directive. That thing is kept. For the principal and the responsible parties, also there's a fundamental principle that is kept from the other directive, in the sense that the producer strict liability, meaning without fault for defective products, remains the foundation of victim compensation. There is a thing that is also super important, and also this is why I wanted to present you that case. If there is no solvent defendant, or not solvent defendant in the EU, for example, if you're buying a laptop from a manufacturer from China, but that was imported from an importer, a EU importer, and then the directive gives you the possibility to sue the importer, not only the producer, for this kind of situations. So there's a liability, a responsible party in the presence of the producer, but also a liability which is subsidiary, the importer, the distributor, the logic service provider, the online platform provider, etc. So only to protect the victim, in case there is no producer in the EU, for example, that can accomplish something in the sense that it can trigger their responsibility. Also, what is super important, and it might be the main focus of the directive, at least from the point of view of the magistrates, the burden of proof, in the sense that it was how it was conceived, the directive, it mitigated the burden of proof in the favor of the victim. So there is a presumption of defect if the producer does not comply with the obligation to disclose the requested violence, because it's this thing that we are always thinking about when we're talking about AI, software, that black box that we cannot see in depth. So a judge can say that can oblige actually the producer to give all the requested evidence, and if they are not giving it to the court, then there is a presumption of defect. It's a relative presumption, of course, but still. And if it does not comply with the safety standards or requirement, that product that is considered to be defect, then it is considered actually a party who wants to demonstrate this, then the existence of the defect is presumed. Like, for example, like was in the Boston Scientific case at the Court of Justice, it was about a medical device that was proven to be a defect, and that triggered actually the possibility for the victims of the whole series actually of that same device to use this kind of presumption of defect without showing that this or every product is like that. I know that I'm out of time. I wanted to tell you lots of other things, but of course that can also be said in some other time. So where does this leave us? I would like just to say the 3 points of the directive. First, that it includes digital products fully within the strict liability, which is super useful. Also, the fact that it protects the victims more efficiently, as I mentioned, especially to the evidentiary rules. And third, that it integrates liability rules with preventive legislation, because at some point I mentioned, like for example, on this slide, the fact that this instrument is connecting with the other ones, with AA Act, Cyber Resilience Act, and there are obligations in those acts that if they are not complied with, then it can trigger that presumption of defect for the product. So they are interconnected, and this is very good, I would say, for justice. So just a reminder that in a digital age, justice must truly evolve, but never to retreat. Thank you so much.
Thank you very much. I think your presentation was really helpful for all of us. This specific field of this directive is actually not that easy to understand for the ones who don't use it, so don't apply it. But you made it very simple for us, so thank you very much. I think that the last points that you highlighted about the possibility to include all the digital products, so the very first example. Secondly, the possibility to protect victims more efficiently. And thirdly, the possibility to combine that directive to other EU instruments. This is actually not new in the framework of the European Union. And in this specific sector, actually, verifying the compatibility and the application of other regulation and directives is very useful also for all the magistrates who need to apply that regulation, in this case, in that directive. Also for the national governments to be aware of the combination of these different acts. So thank you very much. Thank you. So last but not least, is not new in this panel, we have our professor. He will talk about, let me check
What's the name?
Yes, Luigi Romano, full professor of engineering. He will talk about from the University of Parthenope of Naples, what's on the EU's tech radar. So, as you know, I'm so sorry, you're the last one, but we only have 5 minutes.
Let's be one.
Yeah. Yeah, thank you.
Okay, right. So thank you for the invitation. So I will stick to the 5 minutes, possibly even less, so that we have time for questions if you have. So just to set up the scene for my talk, which is quite different from the other presentation, previous presentation. So I want to argue the truth of a popular motto, which comes in different flavors. One is the US innovates, China copies, and Europe regulates. Or we have also seen America innovates, China imitates, Europe regulates, and there are so many others. So actually, the objective of this talk is that I will demonstrate that the EU activity is not limited to regulation, and that we are already working on the link that in other presentations, which came before this one, also the last one by Amelia, there is a direct connection between what I regulate and technical features that are immediately needed in order to enforce that regulation. So I will do this instead of doing on an abstract plane. I will do this by providing evidence of a concrete initiative in the technology plane. I will focus on AI because here focus is on AI, but I might replicate the exercise to virtually any other technological topic. Of course, time will not allow here. Specifically, I will focus on a recent initiative of the European Commission, which builds actually a direct path from regulation to technical solutions. And I want to also emphasize that here I'm focusing on what we might call a production-oriented initiative, but also the research plane is covered. So, and here, this is the example which I bring to your attention. So this is a tender, meaning that it's a purchase of third-party services by the EU Commission. In one of the previous presentations, there was a mention to tools needed to the AI office of the European Commission. This is specifically where this is specifically the topic related to this presentation. The call page, so you see this is a tender, and so it was by DG Connect. It was more than 9 million euros. It opened in July and closed in September. So I will not go into the excerpt of this talk because time does not allow me, but you know the message is that from a requirement on the law plane, there is a requirement and a need on the technical plane. And also, so the final request is that the AI office is seeking support of third-party contractors. So they need the help of trustworthy third-party contractors. And I will focus on one of the lots. This tender was 6 lots. I will focus, actually, I will not focus on any of the lots, but I'll just mention lot 2. So it was cyber offense risk modeling and evaluation. So it was related to basically assessing and monitoring the risk of the use of AI tools. So producing tools for assessing the risk of using AI tools. And also importantly, there was a request for flexible collaboration between the AI offices and the third-party contractor, because in my view, that's the only way things can work. So I here have the concrete objective of a proposal, which was actually submitted. I will not go into the details, but you know, there were specific technical features from risk identification and modeling, quantitative risk assessment, so on and so forth. So these are the technical features which are needed in order to enforce the legal requirement. And so just to conclude, it is not true that Europe is not able to take regulations to the next step, meaning to implementation. In fact, it does so by providing offices and agencies. Just a second. And so it does so. These initiatives are done in a context of open competition. So this is very important. So the mission is clear here by our mission. I mean, the mission of technology provider is clear. We must be able to be on the edge, cutting edge of the technology. We have the skill, the resources are also there. So it's just time to get to work. So I just want to acknowledge Trasta, which is the company which allowed me to use part of the contents, which I actually did not present to you because it was too quick. But I will leave a copy of the slides.
Thank you.
And these are my contact info. So for the university and for the regional competence center where I'm president. Thank you.
Regolando, creiamo la domanda di innovazione.
Closing session.
She's coming. So let me just thank you all for being here. I think it was, okay, Antonella is coming, it arrived. So I wanted to thank you all for your presentation. They were very, very fascinating for all of us and full of new stimulus. I think that we touched the judicial cooperation, we touched digitalization, and we touched also AI in justice systems. How all of them can converge all together to build a smarter and a fairer justice systems, not only at the national level, but at international level as well. So I would like to thank Antonella Ciriello. I think congratulations go all to her for a great effort in the organization of the entire organization. So thank you very much, Antonella.
To follow me in this crazy organization, and I hope we will enjoy future other occasions. And thank you to everybody, School of Judiciary, all the participants and panelists. See you next time. So, thank you to the colleague abroad, Lorenza Calcagno, Linda Tomasello, everybody.
Ciao.
Wojciech.
Thank you. Ciao.
Everybody, thank you. See you next
Thank you.
time in presence in Capri, which is very better than from abroad. Bye bye.
Ciao.
Thank you.
Thank you very much.
Ciao.
Va bene, ragazzi miei. Scusatemi, io ogni tanto devo andare a vedere anche il gruppo civile.
Certo.
E niente, grazie. Mi dispiace che siete stati un poco scomodi qui dentro.
Tra l'altro funzionava benissimo, bravi.
Sì, sì,